Hello, my name is Alexander Williams, and I represent the Australian Society of Authors in their submissions to the Commonwealth Government on proposed changes to safe harbour laws under the Copyright Act 1968 Commonwealth. Before I turn to our substantive submissions today, I would like to explain to you who the Australian Society of Authors, or the ASA as I refer to them in this video, are, and what interests we have in safe harbour laws in Australia. The ASA was formed in 1963 to promote and protect the rights of Australia's authors and illustrators. It is the professional organisation representing over 3,000 members in Australia and overseas who write or illustrate for publication. This includes professionals such as biographers, historians, illustrators, academics and writers. The ASA has a proud tradition in achieving legislative reform in the area of copyright. It was involved in the campaign in achieving public lending rights, educational lending rights, and setting up both the Copyright Agency and the Australian Copyright Council. Now I have explained who the ASA are and our interest in the safe harbour reforms of the government, I'd like to briefly outline the proposals by the government to change the safe harbour scheme. In its draft exposure bill circulated by the government, it proposed omitting the term carriage service provider from the section 116 A B definition and replacing it with the term service provider, which would apply to the safe harbour provisions under the Act. The original proposal to extend the scheme derives from the Australian Law Reform Commission's 2014 report on serious invasions of privacy in the digital era. While we acknowledge that this report concerns privacy and not specifically copyright, we argue that this report is relevant to the proposals of the government to extend safe harbour in the Copyright Act, as it proposed a number of conditions that companies such as Facebook, Google or YouTube would have to abide by if they were to rely on the safe harbour provisions. These conditions included removing or taking reasonable steps to remove material that invaded a person's privacy, providing individuals with mechanisms to remove private content posted on their platforms, and providing a privacy complaint system with the intermediary to respond in a reasonable time to consumer complaints. To start off with, we have a major concern with the proposed law, and that is the breadth of the proposed reforms by the government. In its proposed reform to amend section 116 8B, it was criticised by a number of stakeholders that this definition was too broad. The definition of service provider in this section means, in their proposal, a provider of transmission, routing or connections for digital online communications without modification of their content between or among points specified by the user of material of the user's choosing. This broad definition was criticised by the Australian newspaper and its parent company News Corp, who both alleged that it extended safe harbour to companies that it didn't intend to cover. News Corp went as far as suggesting that it was so loose that safe harbour could be granted to piracy websites. The effect of the definition of service provider was that safe harbour protection went further than what was proposed by the ALRC in its 2014 report. At the time, the ALRC warned against too broad a definition. It specifically highlighted the United States case example, where the scheme was too broad. They argued the US scheme effectively provided immunity from liability for anyone not an author of disputed content, even after they were made aware of the illegality of the posted material, and even after they failed or refused to remove it. We argue in our submissions that there is an issue of balance between encouraging innovation through intermediate immunity and protecting rights holders. And in the proposed law by the government, there isn't an effective balance that was achieved in this consideration. Proponents of the proposed changes to Australia's copyright laws to extend safe harbour provisions point to the United States, EU, and other OECD countries as examples of where an effective balance has been struck between the rights of copyright holders and encouraging innovation. They argue that the extension of safe harbour, in line with the US, will encourage innovation and certainty for global companies and local startups. An example of a stakeholder with this argument is Alex McCauley, the Chief Executive of Startup Australia, He argues that safe harbour is international best practice and will encourage new tech companies and startups within the Australian market. This argument is also reflected by the comments of the chief executive of Redbubble, Martin Hosking, who argued that extending safe harbour is necessary to update Australian laws to deal with the internet's dependence on user-generated content. While these arguments are fair, the ASA submits that the case study of the United States isn't the best to reflect and to base Australia's laws off. Both the US and EU are conducting reviews into their law as they are seeking to modernise and update their laws. The ASA argues that while encouraging innovation, US safe harbour laws have not struck a balance between rights holders and innovation. This is reflected in a review currently being undertaken by the Copyright Agency into Section 512 of the Digital Millennium Copyright Act, or what is known as safe harbour in the US. The review has revealed the same divergent opinions that exist in Australia at the proposed law that the government wanted to put into place. The Computer and Communications Industry Association has argued that Section 512 has encouraged investment and innovation online, while copyright holders such as the American Society of Composers, on the other hand, have argued that the current provisions have enabled internet providers that stream, distribute, or provide access to user-uploaded content to build their business on copyright infringement. The ASA asked, why should Australia adopt a similar provision when US laws have been proven to be inadequate in this regard? Australia's current safe harbour laws are restricted to ISPs, such as Telstra, iNet or Optus. This is largely seen as an error in drafting by scholars such as Nicholas Souza, who have written in this area. In Facebook's submission to the Australian Law Reform Commission in 2014, it sought to minimise the difference between ISPs and other internet intermediaries. It argued that whether a company is a telephone company, an email service provider, or a social network, they generally all have a limited role in generating or providing the communications that are distributed through their systems, and an equally limited role and an ability to know or investigate the facts surrounding those circumstances. In respect to Facebook, this argument is rather simplistic. The ASA submits that ISPs provide the so-called pipes of the internet, while companies such as Facebook, YouTube, or Google directly provide a website for users to share and post material. The ASA agrees with the sentiment of the Coalition of Musicians, who argue that Facebook and YouTube can be distinguished from ISPs based on the ability of Facebook and YouTube to profit, whereas ISPs simply provide the framework of the internet. For this reason, the ASA agrees with the Australian Coalition of Musicians in arguing that there should continue to be a difference in the way ISPs and companies such as Facebook, Google, or YouTube are treated under safe harbour laws. The opposing parties for law reform in this area are having different conversations which aren't addressing the concerns of the other. Large internet companies such as Facebook and Google and startups are arguing for change on the basis of business certainty and encouraging innovation. On the other hand, rights holders such as the Australian newspaper, its parent company News Corp, and musicians are arguing against change on the basis of the threat of lost remuneration and bargaining power. The ASA submits that there needs to be a balance between these competing interests. It is currently missing from the conversation, and it was missing from the proposed laws that were proposed by the government in reforming safe harbour. The ASA submits that safe harbour provisions like those in the United States and Europe shouldn't be adopted in Australia. These provisions have been exploited by intermediaries and have created a power imbalance between intermediaries and rights holders. The ASA does acknowledge that copyright laws need to be updated to support innovation and provide certainty, but we submit that this shouldn't be at the expense of rights holders. We acknowledge the law needs to be reformed and find the arguments of Martin Hosking from Redbubble and Alex McCauley from Startup Australia to be persuasive. We acknowledge there needs to be reform in copyright laws to reflect the reality of the internet in modern times. We submit that any future extension of safe harbour laws needs to strike a balance between providing a defence to copyright infringement and the rights of copyright holders. The imposition of conditions, such as those suggested by the Australian Law Reform Commission in 2014 would be a start in striking this balance. But we welcome the government's consideration of stakeholders' views in this area. And we hope that in listening to stakeholders, both those advocating for change in regards to innovation and those arguing against change due to the issues of rights holders, that they strike a balance between these competing interests and successfully reform safe harbour in Australia.